Hello everyone, good afternoon. I am Dapoli Tomas and my report is the continuation of the Rule 64 formal hearing and disposition of cases, which is the Section 304. So makita ninyo sa ato ang PPT ug mabasahan ninyo kung unsa ang Section 304. So let me read first. Effect of failure or refusal to file an answer. So ingon diri failure of the respondent to file an answer within the reglementary period shall be considered as a general denial of the charges. So, if a respondent gani fails to file an answer within the required time frame, it's treated a general denial for the charges against them. So, halimbawa, imagine someone is accused of a minor infraction within a company. If they don't respond to the accusation by the deadline, it's automatically assumed they are denying the charges. So that's for the section 304. So the next one is the section 305, which is the effect admission by a respondent. So when the respondent in his or her answer admits his or her culpability to that charge, the hearing shall nonetheless proceed in order to determine the degree of his or her responsibility and appropriate penalty to be imposed. So, effect of admission by respondent. Even if the respondent admits guilt, a hearing will still occur to determine the extent of their responsibility and the appropriate penalty. For example, suppose a government employee admits to a minor ethics violations. Despite the admission, a hearing is held to decide the severity of the penalty. Example, warning, suspension. So, let's proceed to section 306, which is the pre-hearing conference. Sabi dito, within 15 or 15 working days from receipt of the answer, the summary hearing officer shall conduct the pre-hearing conference for the purpose. So, within 15 working days of receiving the answer, a pre-hearing conference is held to first is define and simplify the issues. Second one is enter admission or stipulation of facts. The third one is mark exhibit after identification. And the third one is clarify other relevant matters. So, halimbawa, in a workplace harassment case, both parties meet with a hearing officer to agree on the key issues, undisputed facts, and identify documents to be used as evidence. This conference must be completed within 2 working days, and all proceedings are recorded. Here in section 307, which is the order of summary hearing. So, the order summary hearing shall be as follows. So, this section outlines the order of events during a summary hearing. So, first is letter A, the complainant shall adduce evidence with proper identification and marking of his or her exhibits, meaning the complainant presents evidence with proper identification. Second one is the respondent shall then present evidence in support of his or her defense with proper identification and marking of his or her exhibits. Pasabot na the respondent represents or presents their defense with proper identification. Letter C is the proceedings being summary in nature. Direct examination of witnesses shall be dispensed with and sworn statement affidavits of witness after proper identification and affirmation on the truth of the contents therefore shall take the place of their oral testimony except for witnesses who appeared pursuant to subpoena. So pasabot diri ana ang witnesses sworn statements or affidavits replace oral testimony unless a subpoena is issued. The last one is clarificatory questions may be allowed if requested by either party but shall be confined strictly to material and relevant matters and insofar as may be compatible with the ends of justice. Pasabot na clarificatory or clarificatory questions are allowed of if relevant. So halimbawa, during a disciplinary hearing, the person making the complainant presents their evidence first, followed by the person defending themselves, and then the witnesses typically provide written statements but can be called for live testimony if required. In section 308, which is the submission of position paper, so taas man kaini siya, kamo na lang ang magbasa dira. So, in summary, ang hearing officer requires both parties to submit positions papers within 10 working days after the summary hearing ends. So these papers should contain charges, defense, mga claims, and arguments, and can include additional evidence. Halimbawa, after the hearing, both the complainant and the respondent submit written summaries of their arguments, including relevant evidence to support their cases. So in section 309, which is the clarificatory hearing, sabi dito, within 5 working days of receiving position papers, the summary hearing officer or SHO may order a one-time hearing for clarification. Parties can submit written questions to the SHO who decides if they are relevant. So halimbawa, after reviewing position papers in a workplace dispute, the the SHO calls a hearing to clarify specific points raised by either party. Next one is the section 310, which is the right to counsel. Sabi dito na ang parties have the right to legal counsel. Hearings proceed even without counsel, but parties must be informed of their right to have counsel. If unrepresented, the SHO will mark exhibits and may ask clarifying questions. So halimbawa, an employee is informed they can bring a lawyer to a hearing about a disciplinary issue. The hearing proceeds even if they choose not to have one. Section 311, which is the postponement. Postponements are discouraged except for serious reasons like illness supported by a medical certificate. Only 2 postponements are allowed for each party. Example, a hearing is scheduled but the respondent requests a postponement due to illness. Providing a doctor's note, only 1 postponement will be allowed after this. Section 312, Effect of Forum Shopping. Violation of the prohibition against forum shopping shall be ground for the dismissal of the case or motu proprio or upon motion of the respondent. Pasabot na forum shopping is trying to have the case heard in multiple venues, is prohibited and grounds for dismissal. Example, a complainant files the same complaint in multiple agencies, hoping for a favorable outcome. This is discovered and the case is dismissed. In section 313, which is the effect of absence or non-appearance of the complainant. So, in summary, if the complainant misses 2 consecutive hearings, the case may be dropped for failure to prosecute unless the respondent's culpability can be proven without the complaint's testimony. The SHO must try to locate the complainant and witnesses. Example, the complainant fails to attend 2 scheduled hearings. The SHO tries to contact them, but if unsuccessful, the case may be dismissed unless there is other evidence to prove the respondent's guilt. Section 314, Effect of the stance of the complainant. So, if the complainant withdraws their complaint before presenting evidence, the case will be dismissed. So, the SHO will ask the complainant questions to confirm the withdrawal. Example, before the hearing begins, the complainant submits a written statement withdrawing their complaint. The SHO questions them to ensure they understand the implications. Section 315, effect of failure or refusal of respondent to appear. So, sabi dito na if the respondent fails to appear during the scheduled hearings without a valid reason, they are considered to have waived their right to be present and submit evidence. Example, a government employee is notified of disciplinary hearings but chooses not to attend. They lose the opportunity to present their side of the story. Section 316. Application of the principle of res judicata or bar by prior judgment. For prior judgment in administrative case to constitute a bar to subsequent administrative action, the following requisite must concur. Sabi dito na for a prior judgment to prevent a subsequent administrative action, the following must be true. First, there is it must be a final judgment or order. There must be a final judgment or order. Second one is the disciplinary authority rendering the same must have jurisdiction over the subject matter and over the parties. Sabot na the judgment must be on the merits of the case. Letter C, it must be a judgment on the merits and there must be between the two cases identity of party subject matter and causes of action. So the two cases must involve in the same party subject matter and causes of action. So example, a case against an employee was previously dismissed by a court. If the agency tries to bring the same charges, the principle of res judicata may prevent it. Section 317, effect of death. The administrative case against the respondent who dies during the pendency thereof must be resolved as follows. So first is A, in situation where death occurs while the case is pending investigation. So death during the pending investigation, the case should not be dismissed if the respondent was notified of the charges and had a chance to respond. So if the respondent dies before explaining their side, the case is dismissed. So letter B, death during appeal. The appeal continues until its final determination. If the respondent wins, the benefits accrue to their heirs. Example, an employee dies during an investigation after being notified of the charges. The case can continue, however, if they die before being notified, the case is dismissed. If they die during an appeal and win, their family receives the benefits. Section 18, which is the submission of resolution. So, the SHO has working days to submit the resolution to the chief, which is the SOSIA or the Security Agency and Guard Supervision Division, along with the case records. Once approved, the copies are served to all parties within 5 working days. Halimbawa, after the hearing process, the SHO prepares a resolution and submits it for approval. Once na ma-approve na siya, all parties involved receive a copy. Section 319. Context of resolution shall be clear and concise and shall include the following. So, resolution must be clear and concise, including ang facts of the case, issues involved, mga applicable laws, rules, and regulations, findings and conclusions, tapos mga recommendations or disposition. Halimbawa, a resolution summarizes a disciplinary case, outlining the facts, the rules violated, the findings, and the recommended penalty. In Section 320, contents of decision. The decision should contain the full names of the parties. The offense charge, a brief statement of relevant facts, the findings, applicable laws, and mga other pertinent details. Example, the decision in a case details the name of the complainant and the respondent, the specific violation. relevance, facts, and applicable rules. Section 321, which is the service of decision. So, in summary, ang nadariya, sabi dito na, the decision must be served personally or by registered mail within 3 working days of approval to the complainants and respondents' last known address, where proof of service must be attached to the records. For example, the decision is sent to both parties via registered mail, and the mailing receipt is kept as a proof. Section 322, which is the respondent found liable for an offense separate and distinct from that which he was charged. So, in summary, ang respondent may be found guilty of a different offense than original charge provided that the acts constituting the offense were alleged in the complainant and the respondent had a chance to answer. Example, an employee is charged with insubordination but found guilty of misconduct as the action leading to misconduct were part of the original complaint and the employee had a chance to respond it. Section 323, which is the motion for reconsideration. The party adversely affected may file a motion of reconsideration from the decision rendered within 10 working days from receipt of a copy of the decision on the following grounds. So, sabi dito, a party may file a motion for reconsideration within 10 working days of receiving the decision based on, first dariya is letter A, dapat na newly discovered evidence. Sa letter B, decision not supported by the evidence, and letter C is filing a motion stays the decision. Only one motion is allowed and the regulatory office must be decided within 15 working days. For example, a party files a motion for reconsideration claiming newly discovered evidence that could change the outcome of the case. Section 324, which is the finality of the decision. In summary, the decision is final if no appeal or motion for reconsideration is filed within the specified time. The final order is signed by the chief the chief of the SOSIA and served personally or by registered mail. Example, if neither party files an appeal for motion for reconsideration, the decision becomes final and the chief SOSIA signs the order which is then served. Section 325 of or the nature of proceedings. So in summary, administrative proceedings are non-litigious and not bound by strict rules of criminal or civil procedure, but must adhere to due process. The investigating officer can use reasonable means to ascertain the facts, including inspection and expert witnesses. Example, in a working place investigation, the investigator is not bound by strict court rules but must be fair and can use inspections or expert opinions to find the truth. Section 326, Service of Notices and Summons. So, the following shall be observed in the service of notices and summons. So, notices and summons must be served to the respondent. First is in letter A, in person by process server, registered mail, or private courier to the registered business or residential address. Dito naman sa letter B, if personal service files, service can be made by leaving a copy with an administrative officer employee at their business's address or with a household member at their residence. If they refuse to received, service may be made at the barangay office. So, example, a notice is delivered to an employee's home. If they aren't there, it can be left with a family member. If the family member refuses, it can be delivered to the local barangay office. Proof of delivery must be documented within 24 hours. So we are here in Rule 65, which is the filing and service of pleadings, processes, and decisions. Diri sa Section 327, filing of pleadings, in summary, pleadings are filed by presenting original copies to the regulatory office or by sending them via registered mail with proof that the other party received a copy. The date and time of receipt must be indicated on the original and receiving copies with the date and time of actual receipt stamped on the envelope. Example, a party files a document with regulatory office and sends a copy to the other party is via registered mail. Both copies are marked with the date and time of receipt and mailing receipt is attached as a proof. Section 328, which is the service of subpoenas and interrogatory orders. Sabi dito na subpoenas and other interrogatory orders are served personally. However, if a party is represented by counsel, a service to the counsel is deemed service to the client. For example, a subpoena is hand-delivered to a witness. If a party has a lawyer, the subpoena can be delivered to the lawyer instead. Section 329, which is the service of final orders or decisions or resolutions. In summary, final orders, decisions, or resolutions are docketed before release and served as personally or by registered mail to the parties. For example, a final decision is recorded, then sent to both parties via registered mail. Section 330, implementation of orders, decisions, or resolutions which have become final, executory. In summary, orders, decisions, or resolutions that have become final are referred to the office concerned for implementation. The regulatory office or appellate body is tasked to handle the implementation within 5 working days of receipt, with copies furnished to the complainant respondent, chief, SOSIA, and the DCSG. For example, a final decision in disciplinary case is sent to the responsible office, which is must begin implementing the decision within 5 days, notifying all relevant parties. In Section 331, appropriate return, sabi dito na the authorized personnel tasked with implementation must make the appropriate return to the disciplinary authority or appellate body indicating the action taken on the referral order for implementation. For example, na after implementing a final decision, the responsible personnel must report back to the disciplinary authority, detailing the steps taken to implement the decision. So, we are here in Rule 66, which is the appeal. According to Section 332, perfection of appeal. So, in short, an appeal is perfected by filing and serving a notice of appeal with the DCSG within 10 working days of receiving a decision subject to appeal. A copy must be furnished to the other party, so the SOSIA then forwards the original case to the records to the CSG within 3 working days. So, for example, ang party files notice a appeal within 10 days and provides a copy of the other party. The SOSIA then sends a case file to the CSG within 3 days. In Section 33, Notice of Appeal and Memorandum of Appeal, appellant shall observe the following. Sabi dito sa A notice of appeal and memorandum of appeal must contain material dates, assignment of errors. So, pangkalahatan na to dito sa A, B, and C. And specific appellate body, appellant contact information. Then the appellant is referred to as the appellant and the prevailing party as the appellee. The last one is the appellant must submit a memorandum of appeal in 3 copies within 15 working days of filing the notice of appeal. So, for example, the notice of appeal includes key dates, lists errors in the original decision, specifies the appellate body, and provides contact information. The last section that I'm going to report today is the section 334, which is the dismissal of appeal. When the appellant fails to comply with the requirements provided in the preceding section of this IRR, the appellate body shall direct the compliance thereof within 10 working days from receipt of the order within a warning that non-compliance with the requirements shall be construed as failure to perfect an appeal and shall cause the dismissal of the appeal with prejudice to its filing. So, in short nga, if the appellant fails to comply with the requirements, the appellate body directs complainants with 10 working days for non-compliance resort in dismissal of the appeal. For example, if the notice of appeal is missing required information, the appellate body gives the appellant 10 days to correct it. If they don't, the appeal is dismissed. So that's all for my report. Good afternoon.